applications and appeals in the matter of Uduezue and Bexley London Borough Council and Zaman and London Borough of Waltham Pole.
Mr. Burton, you're obviously intending to go first. Can I check first of all, you know we're going to rise at 12:45 today?
I was not aware of that, but that's fine.
So the plan is we're sitting at 10 o'clock because we're intending to rise at 12:45 and resume at 2:10.
Most grateful.
The other sort of housekeeping point is, have you agreed between yourselves how to organise the next 1.5 days?
My lord, my ladies, we have, but obviously subject to your approval. What we were going to propose, or are proposing, subject now to the slight variation in times, but in terms of the allocation, it should stay the same. That myself would open the case for, and indeed make the submissions on behalf of Miss Zaman, the appellant in the first appeal. Mr. Hodgson would then make his submissions on behalf of Miss Uduezue. And then we would have Mr. Grundy-King's counsel give his response in the first appeal, Zaman, this afternoon. Now, with the earliest start, we had thought that Mr. Calzavara may start his response to Uduezue today. That may no longer be the case. And in any event, both Mr. Hodgson and I would endeavour to finish our replies before lunchtime tomorrow. Notionally, Mr. Hodgson and I have been allocated 2 hours, 15 minutes to get both our primary submissions and reply in. And both respondent counsel have been given about an hour and a half to reply.
Sorry, that's each.
Yes.
That's not cumulative, so it's
that's
2 hours and 15 minutes for both appellants.
I do apologise if that wasn't clear. Sorry, that is the intention. Yes.
So 4.5 hours between the two appellants?
Yes.
Yes. Does that work?
Well, that should bring us in on time. The only caveat is that whilst the substantive issues don't cross over that much, there is quite a lot of law that's relevant to both appeals. And I will be opening with a brief introduction to quite a lot of that, which may eat into my submissions time. But nevertheless, my learned friend Mr. Hodgson and I are still confident that between us we won't exceed the time that's been allocated for the appellants.
I'm afraid I've got myself confused. So 4.5 hours for the appellants between them?
My lord, yes.
And how many hours have we got today? It's 2.25 after lunch, 2.5 before, 4.75. Yes. And then 3 hours for the councils. It doesn't quite work on what we were envisaging as the timetable.
No, it would appear that Mr. Grundy, if we're lucky, will finish his submissions today, potentially, if we are sitting till 4:30.
Let me just check whether...
Sorry, don't...
Yes.
Most grateful.
We are happy to sit, I think we are happy to sit till 4:30.
I'm most grateful. If that's the case, then on my quick calculations, but there are some things I like doing on my feet. Mathematics is not one of them.
I think broadly there might be half an hour. Is this right?
Well, if I take my hour and 45 this morning, then I'll be finishing around about 11:45. Mr. Hodgson would then start his hour and 45, and would then, if we're finishing at 12:45, was that we were finishing today?
Yes.
So he would be able to fit an hour of his submissions in theory, before lunch, and then resume with his 45 minutes at 2:10. Were we going to start?
Yes.
So that would take us to 2:55, and at that point, Mr. Grundy would be able to start his submissions, let's say, around about 3 o'clock. And if we went to an hour and a half there, that would be 4:30, and that would be his notional allocation, as I understand it.
I think I shouldn't waste more of your time trying to sort out the precise detail. And in terms of the order of events, that sounds fine, I think. Let's hope that you manage to keep to your timings.
Yes, as I said, my learned friend, Mr. Hodgson, and I did speak this morning about just trying to make sure we, within our envelope, at least finish in time. And I'm confident we'll be able to do that. There might be some variation within that, just keeping in mind the issues about the law.
Yeah.
My lord, my ladies, if I may then just to introduce properly, I appear on behalf of the appellant of Mr. Zaman, on behalf of Miss Zaman, I should say, along with my learned junior, Miss Sharma Gibbon, who sits behind me. And indeed, Miss Zaman is intending on coming to court today, but I'm not sure she's arrived as yet. Mr. Grundy, King's Counsel, appears on behalf of the local authority, along with Mr. Mullin. That is, of course, Waltham Forest, London Borough Council. As I mentioned, Mr. Hodgson and Mr. Grutas appear on behalf of the appellant, Miss Uduezue, and Mr. Calzavaro appears on behalf of Bexley, the respondent in the second appeal.
Yeah.
Perhaps if we refer to them as the first and second appeals, if that's acceptable. Great.
Yes.
So, my lord, my ladies, the structure I intended to follow was as follows. I would introduce the decision under challenge and give a very brief account of the facts in relation to that. Grounds of appeal in summary. 3, the law, statutory provisions, and some of the main propositions from the cases. I'll only be taking to you, I think, 3 of those cases, potentially 4. Then look briefly at the documents in the Zaman case, including, of course, the review decision, which is the subject of the appeal, and then the grounds of appeal themselves. I hope that by the time I get to the grounds of appeal, I will have done enough work to make it fairly clear where I'm going with the grounds of appeal. And that may be optimistic, but that's the hope. So, my ladies, my lord, the decision on the challenge and the briefers of facts, item 1. So this is, of course, a second statutory appeal against the review officer's decision of the 12th of November 2021, upholding its decision of the 22nd of July 2021 to discharge the main housing duty to the appellant by way of an offer of accommodation made on that day, the 22nd of July 2021, at 16 Longshore Street, Stoke-on-Trent, herein referred to as the property. The main housing duty, pursuant to section 193 of the Housing Act 1996, was notified to the appellant on the 2nd of October 2020, and that is a duty to secure that suitable accommodation is made available for her and her 3 children, who at the time were aged 10, 8 and 4. This was an offer of a tenancy with a private landlord, referred to as a PRSO offer, which has legal consequences. When we come on to look at the scheme, I'll explain that. It was also obviously an out-of-borough placement. The accommodation is 170 miles away from the appellant's former home at 10 Lime Street, East 17. Acceptance or rejection of a valid PRSO that the local authority is satisfied is suitable for the particular applicant and their household may lead to a local authority discharging the main housing duty pursuant to section 1937, capital A, subject, of course, to any review decision made pursuant to section 202. The appellant did indeed refuse the property offered to her on the 22nd of July 2021, sought a review of the decision to discharge the duty to her. The decision under challenge is indeed that review decision, which, as I said, was made on the 12th of November 2021. His Honour Judge Gerald dismissed the appellant's appeal in the County Court, statutory appeal, section 204 of the Act, on the 21st of July 2022. Meantime, the appellant and her 3 children are, as I understand it, accommodated by the local authority pursuant to a different statutory scheme, the Children Act 1989. just for the avoidance of any doubt, that provision is not one which is linked to mandatory duties or any long-standing obligation to accommodate. It's effectively a holding position pending resolution of these proceedings. And again, just for clarification, in the event that the appellant is successful in this appeal, the decision to discharge would presumably be quashed. Then, of course, it would be open to the local authority to revisit that decision. In the event that it remade the decision, we'd be back to the situation we're in now, where there would be no outstanding obligation to secure accommodation for the appellant and her family. Of course, if the decision was overturned, the duty would be revived and the appellant would stand to be made another offer of accommodation in due course. My ladies, my lords, number 2, grounds of appeal in summary. With the leave of Lord Justice Arnold, the appellant appeals to the Court of Appeal on 3 grounds. This is, of course, a second of appeal, and Lord Justice Arnold found that the grounds all had a real prospect of success and indeed raised important points of principle, although he did express some doubt about ground 3, and as I'll be explaining in a moment, the appellant is no longer pursuing ground 3 before you this morning. Although the grounds as expressed, and you can see those in the core bundle at page 15 to 16, are articulated as challenges to the learned judge's conclusions, it's common ground at the bar that the focus of this court is indeed the review decision itself, 21st of November 2021, and the authority for that is Dinesh versus Kensington Chelsea Royal Borough Council 2007 One Weekly Law Reports 69 at paragraph 30. I'm only citing that because it's not actually in your bundle of authorities. Tried to keep them to a minimum if we could. Never quite achieved that, but we've done our best. As a consequence of that, I would ask you to read the grounds of appeal as slightly rephrased so that it's clear what we're focused on, which is the review decision and not the decision of the learned judge. So just looking at ground 1.
Should we get that out?
Oh, that might be helpful in most cases. As I say, that's page 15 and 16 of the core bundle. The first ground, ground 1, would be that the respondent erred in concluding that it had complied with the duty to offer accommodation within its own area if reasonably practicable, or failing that, as close as possible to its own area. I'll come back to the further particularisation of ground 1 in a moment, if I may.
But there, for present purposes, the reference to the judge can stand because it's or perhaps it can't. It doesn't really matter, I suppose. Yeah.
Yes, I mean the paragraph 4 would also read that the respondent's decision was unlawful because, and then we would list those 3. I'm going to come on to say something briefly about those in opening in a moment, if I may.
Yes.
Ground 2, similarly, I would invite your ladyship and your lordship to read it as follows. The respondent erred in concluding that the property was affordable because it failed to consider affordability by reference to anticipated income and expenses in the area of the property.
Can you just say that again? So the respondent erred
in concluding that the property was affordable because it failed to consider affordability by reference to anticipated income and expenses in that area.
Yeah.
So, my ladies, my lords, just for the benefit of further clarification, being crystal clear about what the appellant's grounds are at the outset, and what therefore the issues are for the court. As I said, I'd come back to the 3 further particularisations in relation to ground 1. Before I do that, just to remind the court, you may have picked it up from your reading already, that it's common ground that there are two related duties in this context. There is a duty to provide accommodation in borough where reasonably practicable. In fact, the statute is expressed the other way round. There's an obligation to provide accommodation in borough unless it's not reasonably practicable to do so. In borough duty, we've described that as in the supplementary skeleton. Where it's not reasonably practicable to provide accommodation in borough, there is then a duty to provide accommodation as close as possible to the applicant's previous home. And we've described that as the out of borough duty, just for the purposes of analysis and clarity. So ground one has three limbs, A, B, and C. As set out in the skeleton and refined to some extent in the supplementary skeleton, ground 1A is that the respondent's PRSO allocation policy is unlawful as it does not apply the out of borough duty to offers made in Zone C.
Sorry, can you just repeat that?
Of course, my lady. The respondent's PRSO allocation policy is unlawful as it does not apply the out of borough duty to offers made in Zone C, i.e. Zone C is effectively treated as being of a uniform distance under the allocation policy, and allocation officers are not told to allocate the nearest Zone C property to someone they have otherwise prioritised as being eligible for a Zone C offer. Zone C, you may have picked up, is the entire country outside of London and neighbouring, Greater London, I should say, and neighbouring counties. Related to that under ground 1A is that the PRSO allocation policy fails to apply a reasonable time provision to the out of borough duty. In other words, there is no instruction to allocation officers to consider waiting for a period for something closer in Zone C to become available. Of course, if there's no obligation to apply the out of borough duty within Zone C, then there would be no purpose in waiting longer once you've got a property available in Zone C. But if the appellant is right that once you're in Zone C, you still need to be sure to offer the closest possible accommodation, there may therefore be an obligation to wait a bit longer to see if something comes up that's closer, particularly when you're looking at a putative offer which is as far away as Stoke is from Forest.
I didn't read that in ground 1, or even in 1A. You say it's inherent in your ground 1.
It is set out in the skeleton argument.
Yes, but it's not in 1A. Or B or C.
Well, it's maybe not explicitly made clear in ground 1A in the grounds. I accept that. I hadn't understood there to be any objection from the local authority on that. The skeleton arguments both engage in some depth in this question about reasonable time. If I need to amend the grounds in order to clarify that, can I make that application on the premise that I don't anticipate it will be opposed?
Mr. Grundy, is that something on which you wish to comment on at this stage?
Well, with my Lady Justice Asplin, I agree that the supplementary skeleton argument puts the case in a rather different way insofar as the time is concerned, and that hadn't been presaged previously. I'm not going to object to it being done, but I would like it. This is the 4th iteration that the appellant has to have a go at her grounds.
So perhaps Mr. Burton.
But sorry, I don't object to it being. I don't require Mr. Burton to make an application to amend his grounds. When I got the supplementary skeleton argument, I understood what was being argued. I accept that I hadn't really understood previously, and it may be that our skeleton argument didn't engage with what was being argued. but I'm going to respond to it orally.
I suppose, perhaps for good order, overnight,
Yes.
you and Ms. McGibbon could produce a tidied up version, so we have a piece of paper that reflects what you're saying.
Of course, my lord. Just for reference, at this stage, the point about time in the context of ground 1A is set out paragraph 27 of the appeal skeleton. And then, as my learned friend indicates, to some extent, extended in the supplementary skeleton. Of course, I'll come to that in due course. But yes, we will provide that and make sure that it's...
I think my lady is raising a point that is worrying me too, which is I'm not aware of a supplementary skeleton.
No.
Oh dear. I'm terribly sorry not to clarify that beforehand. That is fairly significant in the sense that it does set out, as I say, in some detail, two things really. A degree of elaboration, but I think we dealt with the primary piece of elaboration, but also an attempt to try and respond to some of the points raised by the local authorities. It was prepared for two reasons. One, because we were going to hear both of these appeals together, so we wanted to say something about that. And two, because we knew this time was going to be more limited, we thought it would be useful to set out in more detail, effectively, the appellant's submission. So it was intended to assist, believe it or not.
Yes.
I'm terribly sorry it hasn't got to you.
It looks
My lord, we can give you
like
two
you'll
copies.
have
My
a bit.
learned junior and I can give you ours. We have them in electronic form. And I think Miss Gibbon has a spare copy, so that would be one each.
Thank you.
Please.
This one needs stapling. If you've got a staple. Well, one of you may prefer not to have a staple.
I have a stapled one for the whole bunch as well. We can obviously make sure versions in whichever form your ladyships and my lord would like at the adjournment. I mean, I don't know whether or not you would like to consider taking an opportunity to read it before we carry on with submissions. Or
I think it's going to make sense, provisionally at least, thank you very much, for you to carry on the basis that we can read through what you say at some convenient point.
I'm most grateful. Yeah, indeed. My learned friend is just pointing out that we did receive an order granting us permission to rely on that skeleton.
This is the order of Lord Justice Underhill, so I'm not
Yes.
quarrelling with the proposition you had permission, but it just hadn't reached us, I'm afraid.
Well, I'm very, very sorry that that's happened, and I should have checked in the opening. I do apologise. That's going to slow me down a little bit. I will do my very best to try and minimise that. So carrying on, I was trying to give a brief description of the grounds so it's clear what we're arguing. So ground 1A is those 2 points about the allocation policy, which are intimately related to one another. Ground B is a discrete point in the context of ground 1 overall, which is that the review decision is unlawful because it failed to assess whether the appellant could have afforded 2-bedroom accommodation closer to Waltham Forest. The appellant having made it clear she was willing to live in a smaller property and could continue to take advantage of support she had in the area and thereby save money. And moreover, the allocation policy itself allows for that eventuality. Notionally, the appellant is entitled to a 3-bedroom property, but the policy says a 2-bedroom, 1-bedroom smaller property can be allocated. She indicated a willingness to consider that, but the review decision proceeded on the assumption she needed a 3-bed, calculated her affordability on that basis, and thereby decided she had to be in Zone C. And then ground 1C addresses the acquisition policy as opposed to the procurement policy, and contends effectively that the respondent has not complied with its obligation under its allocation policy, or indeed to demonstrate that it has complied with its legal obligation to provide accommodation that is closer than Stoke. Specifically, it has not explained why the appellant was not offered somewhere closer in Zone C than Stoke, or why the London Borough of Waltham Forest was unable to acquire something closer in Zone C than Stoke. There is specific reference in the skeleton arguments to the possibility that doesn't appear to have been considered that accommodation could have been looked for in the Midland centres, and examples have been given of Norwich, Peterborough, Birmingham, Northampton, Stafford, etc., all of which are substantially closer to its own area than Stoke, and in any event did not comply with its allocations policy as regards the specific offer of 16 Longshore Street. We say that the burden on the local authority to demonstrate compliance with its obligation to provide accommodation as close as possible within Zone C is not evidenced by the review decision, or indeed the evidence provided by the local authority in the court below, or indeed in the acquisitions policy itself. So we look at all three of those. My ladies, my lord, I've already said what the specific point in ground 2 is, which is about the affordability point. The sub-issue there is the respondent's contention in paragraph 78 of its skeleton argument. In the absence of a, quote marks, more precise representation on the review, there was no obligation on the reviewing officer to carry out a more extensive affordability assessment. As I've already indicated, because of issues of time, the appellant will not pursue ground 3. And as I've already indicated on the question of relief, the appellant is seeking a quashing of the review decision. My ladies, my lords, stage 3 of my submissions, the law. I could invite the court to turn up the authorities bundle. I very much hope you've got that.
Yes. There ought to be 3 bundles, a core bundle, supplementary bundle, and a bundle of authorities.
Well, we've got 2 bundles of authorities.
Oh, I do apologise. In hard form, yes, it may come in 2. Yes, of course, that's right. I'm grateful, my lady.
Yes, yes. Sorry.
I'm going to begin by looking at behind tab 2, which is the Housing Act 1996. Section 182, the first section, which is the provision that deals with guidance by the Secretary of State. And it's a classic shall have regard duty. And indeed, the guidance in this case is relevant, so we will be looking at it in due course. Section 193 is the principal material provision. This is where we see at subsection 2 what's described as the main housing duty, which kicks in where a local authority is satisfied that an applicant is homeless, eligible for assistance, has a priority need for accommodation, and is not intentionally homeless. If so satisfied, subject to the right to refer the applicant to a different local authority on the premise that they have a local connection with a different local authority, it is then a mandatory duty on the local authority to be fulfilled immediately to secure that accommodation is available for their occupation. Subsection 3 makes it clear that that duty can only come to an end in accordance with the subsequent provisions in section 193. It's an exhaustive list. We are interested in section 1937 capital A, which is on page 9 of your bundle of authorities. The authority shall also cease to be subject to the duty under this section if the applicant, having been informed in writing of the matters mentioned in subsection 7a(b), accepts a private rented sector offer or refuses such an offer. Very briefly, that was an innovation introduced by the Localism Act 2011, which allowed for the first time local authorities to once and for all discharge a duty by the provision of private rented sector accommodation. Previously, they were allowed to perform the duty by providing private rented sector accommodation, but not finally discharge it. Potentially the only material relevance to you in this case is that once there is a final discharge, there is no mandatory obligation to revisit the question of suitability. Whereas if it's a performance situation, then the local authority has an ongoing duty to consider suitability, which may indeed also include location and whether or not it might now be reasonably practicable to bring the particular household back to the borough or closer to the borough. That doesn't apply when you're dealing with a discharge offer of private rented sector accommodation. (7)AC, if I may, describes what a private rented sector offer is, which includes, for example, that it should be for a minimum period of 12 months and is made with the approval of the authority in pursuance of arrangements made by the authority with the landlord with a view to bringing the authority's duty under this section to an end. So it is not a valid PRSO if it is not so approved. And then 7F, the local authority shall not approve a private rented sector offer unless they are satisfied that the accommodation is suitable for the applicant. The remaining part of 7F, not material to our case. Section 202, my ladies and my lord, which is page 17, is the right to request a review.
I'm so sorry, I'm slightly behind. If you would just give me a moment.
Of course.
Yes, I'm sorry, you'd gone on from 1937AF to... You just gone on...
7F, my lady.
7F.
I'm just panicking, there was an AF. I don't believe there is an AF.
No,
but
7F.
7F, I'm most grateful. Yeah, and then moving on to section 202.
Thank you.
Which is at page 17. Now, this is the right to request a review of a decision. It's a mandatory right. And at subsection 1B, you see that you have a right to request a review of any decision of a local authority as to what duty, if any, is owed to him. And the case law makes clear that that encompasses a decision that a duty is not owed to somebody. And then pulling down to G, any decision of a local authority as to the suitability of accommodation offered to him by way of a private rented sector offer within the meaning of section 193. My lord, my ladies, section 203, just for one quick point, is the procedure on a review. This is page 21 in the bundle. It's 203 subsection 4. If the decision on the review is to confirm the original decision on any issue against the interest of the applicant, there is a duty to provide reasons. Section 204, page 23, is the statutory right of appeal on a point of law. Section 206, we see three provisions, 6, 8 and 10, dealing with discharge of functions. Section 206, the local authority may discharge their housing functions under this part only in the following ways. And there we see either securing accommodation provided by them or provided by somebody else. And subsection 2, a power to charge for such accommodation. Of course, is routinely exercised. Section 208, discharge of functions out of area placements. This is where we see the in-borough duty. Subsection 1. So far as reasonably practicable, local authorities shall, in discharging their housing functions under this part, secure that accommodation is available for the occupation of the applicant in their district. Then section 210, suitability of accommodation. You've seen in 206 that the obligation is to provide suitable accommodation. And here we see at subsection 2 a power in the hands of the Secretary of State to make orders specifying circumstances in which accommodation is or is not to be regarded as suitable and matters to be taken into account or disregarded in determining whether accommodation is suitable. My Lord, my Ladies, tab 3, Children Act 2004. Section 11 thereof, in particular section 11 subsection 2, which is page 33 of the bundle. I could just invite the court to read subsection 2. It's common ground in relation to that duty, so I don't need to take you to the authority. But that's a duty that applies both in a general sense to strategic decisions, but also to individual decisions made on behalf of individuals. My Lords, my Ladies, I took you to the power in section 210(2) in the Housing Act 1996 to make orders in relation to suitability. We have two relevant orders. Tab 4 deals with affordability. Article 2, matters to be taken into account in determining whether it would be or would have been, this deals with two different scenarios. Either a scenario where the local authority is looking to see whether it would have been reasonable for somebody to continue to occupy accommodation, most relevant to the question of intentional homelessness, but more relevant for our purposes, in determining whether accommodation is suitable for a person, there shall be taken into account whether or not the accommodation is affordable for that person, and in particular the following matters. A, financial resources available, so income. B, costs in respect of the accommodation and outgoing. D, the person's other reasonable living expenses. Tab 5 is the 2012 order, which deals with location. The circumstances in which this order were made have been the subject of judicial discussion, and I'll be taking to that in due course. But its terms are set out there. Would ask you to note that in Article 2A, it states where the accommodation is situated outside the district of the local housing authority, the distance of the accommodation from the district of the authority is a mandatory consideration. It's a freestanding issue. It is not linked to B or C or the impacts of being far away. It's a freestanding consideration. Article 3, I believe, was at one point relevant to the second appeal. I'm not sure it any longer is, so I'm not going to take the court to it at this stage. My Ladies, my Lord, I said that there was guidance that was relevant in this appeal. That's behind tab 6. And in particular, chapter 7 of the Homelessness Code of Guidance. We have here the version that was in force at the material time. It's subject to amendments from time to time. And indeed, some of the cases refer to earlier versions, not in a way that the appellant considers to be material. I won't speak on behalf of Mr. Grundy in that regard at this stage. I'm not entirely sure if he relies on any changes in the guidance. We say they're immaterial, such as there are. So this is Chapter 17, Suitability of Accommodation. And at 17.4, just highlighting a few points for you. 17.4 speaks to something that had already been established in case law, which is while space and arrangement of the accommodation is going to be relevant to determinations of suitability, suitability must embrace all aspects of accommodation in light of the relevant needs, requirements and circumstances of the homeless person and their household. The location of the accommodation will always be a relevant factor. (17.9) Housing authorities are required to assess whether accommodation is suitable for each household individually, and case records should demonstrate that they have taken the statutory requirements into account in securing the accommodation. Just making sure I skip anything I was going to say about Article 3. It's no longer an issue. So if we come down to 17.4.5, which is at page 47, my lords and my ladies, we see here affordability. And effectively, word for word, you see the order repeated. And then we have one material paragraph, 17.46. Housing authorities will need to consider whether the applicant can afford the housing costs without being deprived of basic essentials such as food, clothing, heating, transport, and other essentials specific to their circumstances. Housing costs should not be regarded as affordable if the applicant would be left with a residual income that is insufficient to meet those essential needs. Housing authorities may be guided by universal credit standard allowances when assessing the income that an applicant will require to meet essential needs aside from housing costs, but should ensure that the wishes, needs and circumstances of the applicant and their household are taken into account. The wider context of the applicant's particular circumstances should be considered when considering their household expenditure, especially when these are higher than might be expected. And then an example is given of a household that might have higher than normal costs because of the presence of a disabled child. And then we see in the guidance location of accommodation. And immediately what's mentioned is section 208, which is the in-borough duty as described by the appellant. Section 208 does not, in terms, reference suitability, but it's plainly relevant to location, and location is, as we've seen, always relevant to suitability. So that explains why we see the discussion of section 208 included within the chapter of the guidance dealing with suitability. 17.4.8 is a paragraph that was introduced after the main decision on location, and in particular the out of borough and in borough duties, which is the Enzo Lamiso case that I'll be taking to you in due course, where it says housing authorities, particularly those that find it necessary to make out of district placements, are advised to develop policies for the procurement and allocation of accommodation which will help to ensure suitability requirements are met. This would provide helpful guidance for staff responsible for identifying and making offers of accommodation, and would make local arrangements and the challenges involved with sourcing accommodation clearer to applicants. 17.9. Where it is not reasonably practicable to secure accommodation within district and an authority has secured accommodation outside their district, the housing authority is required to take into account the distance of that accommodation from the district of the authority. Where accommodation which is otherwise suitable and affordable is available nearer to the authority's district than the accommodation which it has secured, the accommodation which it has secured is not likely to be suitable unless the applicant has specified a preference or the accommodation has been offered in accordance with a published policy which provides for fair and reasonable allocation of accommodation that is or may become available to applicants. That reference to policy and fair allocation is rooted in the findings in the case law, which predated the inclusion of those words about policies in the guidance, to the effect that it is permissible for local authorities to hold back or retain some properties
For emergencies.
for the benefit of families they know are likely to crop up and are likely to have higher priority. That's absolutely accepted. There's no challenge to that principle in these appeals. But that's what that's speaking to, if I may say so. And then 1750, again we see in the clearest possible terms the outer borough duty. Generally, where possible, housing authorities should try to secure accommodation that is as close as possible to where an applicant was previously living. I can therefore move away from the guidance now. I don't need to say anything further about Article 3, etc., and look at the case law, if I may. So tab 20, my ladies and my lords, is the Enzalamiso case. Not the first case to consider Section 208 and the in-borough and outer-borough duties, but the only Supreme Court case to do so, and one which, if I may put it this way, drew a line in the sand, as we shall see in due course, in terms of how one should approach these questions. My lord, my ladies, if I can just say something briefly about the facts of this case, which we see at paragraph 2 of the judgment of Lady Hale, which was agreed by all of the other justices. Miss Enzalamiso was a single mother also. She was residing within borough. She was then subject to reductions in her social security, which meant she was no longer able to afford a private rented sector accommodation. And from there, she was ultimately evicted. She was there found to be entitled to the main housing duty. And then at paragraph 4, she was offered accommodation in performance, not discharge of that duty, in Bletchley near Milton Keynes. The offer letter explained that there was, as we see at paragraph 4, severe shortage of accommodation in Westminster. It's not reasonably practical for us to offer a Westminster home for everybody who applies for one. That is why we've had to offer you accommodation in Milton Keynes. Although it's outside Westminster, having considered your circumstances, we believe this accommodation is suitable for you. The appellant rejected the offer. Paragraph 5, the local authority responded and said, well, based on your circumstances, there's no reason for us to place you within the borough of Westminster. And as a consequence of her refusal, then discharged their duty as they were entitled to do. Just for the sake of clarity, if that's in any way confusing, even when you're dealing with an offer of accommodation which is in performance of the duty, not in discharge of the duty, refusal of that accommodation, if it's considered suitable, will nevertheless result in discharge of the duty. The consequences are the same. The only material difference is where you're in discharge of the duty, as I mentioned earlier, the duty is final if you accept it, whereas if you're performing the duty, the accommodation is accepted. Then there is this continuing obligation to review suitability. Paragraph 7, the review in Ms. Enzalamiso's case was completed on the 27th of May 2013 and concluded that the property was suitable and affordable. If I can put it this way, the decision letter purported to deal with the social factors which were relevant to Miss Enzalemiso's relocation to Milton Keynes. As we'll come on to see, did not adequately deal with those, or indeed the particular requirements of section 208. It did, however, mention 208, or did at least engage with its terms, and we see what was said in the decision letter, paragraph 8 of the judgment, where it said that the council's temporary lettings team carefully assessed each application based on the individual circumstances of each household member and decide what type of accommodation would be suitable for the household. Given the shortage of accommodation in Westminster and all your circumstances, including those above, I believe that it was reasonable for the council to offer your household this accommodation outside the Westminster area. It's important to note that the authority hadn't provided any evidence of their policy in relation to the procurement of accommodation in order to fulfil their obligations under the 1996 Act, although it did provide evidence as set out in paragraph 9 about the difficulties it was encountering, how much of its temporary accommodation was therefore being provided outside of the local authority, and indeed explained that that was partly driven by changes in welfare benefit reforms. Ultimately, the appeal was unsuccessful in the county court level, and that's eventually how, and indeed in the Court of Appeal, and that's how it found its way to the Supreme Court. Then we see at paragraph 13 the introduction of the 1996 Act and the guidance. Section 206 and 208 are mentioned there. I won't take you through those again because we just looked at them. And then paragraph 14, this has since been fleshed out in statutory guidance. And paragraph 16.7 of the then guidance mentions section 208 specifically. And then paragraph 15 of the judgment in Enzalemiso is where Baroness Hale deals with suitability and the point that the location of accommodation will be relevant to suitability. And you'll see the passage there that we just looked at a moment ago in the passage of 1741, where it said that wherever possible, local authorities should secure accommodation that is as close as possible to where they were previously living. Then at paragraph 16, there is discussion about how this has been expanded upon. And it's important to understand this because we start to see where the court identifies the policy rationale for these changes. So paragraph 16, there's reference to the power in section 210.2. And then the sentence that begins, it had come to light. My lords and my ladies see that. It had come to light that some local authorities were seeking accommodation for households owed the main housing duty far outside their own district. The government was therefore willing to look at that, and there was thereafter a consultation exercise. And in response to that consultation exercise, the government had made it clear that it's neither acceptable nor fair for local authorities to place households many miles away from their previous home where it is avoidable. The method chosen to tackle that problem was the statutory obligation to take the location of the accommodation into account that we looked at a moment ago. As I said, at that point, that's a freestanding obligation. It's not necessarily tied to other facets of suitability. In recognition of the inherent value of ensuring that applicants remain as close as possible to their former homes. At paragraph 18, the government's response to the consultation emphasised that the order does not prevent or prohibit out-of-borough placements where they are unavoidable, and then issued the supplementary guidance which accompanied the order, some of which has now been reincorporated into the main homelessness guidance in the version that was in play when the decision was made in Miss Zaman's case. And you'll see there that's effectively in the same terms. But what you don't see is the reference to policy that we see in the modern version, and that becomes clear why in a moment. And then paragraph 19 is the paragraph most frequently cited as being the ratio of Enzela Miso. The effect, therefore, is that local authorities have a statutory duty to accommodate within their area so far as this is reasonably practicable. Reasonable practicability imports a stronger duty than simply being reasonable. But if it is not reasonably practicable to accommodate in borough, they must generally, and where possible, try to place the household as close as possible to where they were previously living, what we describe as the out of borough duty. And then the final sentence, the combined effect of the 2012 order, the supplementary guidance changes and was meant to change the legal landscape as it was with previous cases dealing with out of borough placements policy, such as UMSAT and Calgan. You do have Calgan in your bundle. I'm not going to take you to it this morning. I may have to in reply if anything crops up. Then we see at paragraph 20, just an important point that does relate to Calgan, which is here is where Baroness Hale confirms that whilst the 208 duty, which is about the in-borough obligation, is not in terms referred to in section 202 as a decision that someone has a right to seek a review of, there is a right to seek a review of suitability, and thereby one can challenge any issues about location that way. The Calgan case, decision of Mr. Justice Elias, as he then was, had taken a different view and said that you couldn't, in fact, raise 208 issues in a Housing Act appeal, or indeed on review, and therefore a Housing Act appeal. But that was clarified in this case. Of course, in relation to the outer borough duty, which comes from the guidance and has always been linked to suitability, that issue would never, in fact, have arisen. On children's welfare, there is just the reference to section 11 and at paragraph 24, the point I made earlier that that also applies to individual duties, and that the section 11 link to best interest of the child, which are to be treated as a, not the, primary consideration, applies to suitability decisions, which of course would include location. In that case, Westminster had reached the conclusion that because the children were not at exam age, they didn't need to consider anything further about the impact of moving the children to Milton Keynes. And Baroness Hale said that that was unlikely to be, well, was not enough to fulfil the functions under section 11, because you had to have a broader inquiry into the impacts of relocation on the children's welfare. So, moving down then to paragraph 31, evidencing and explaining the authority's decisions. Everything that's said here is plainly directed towards both the in-borough and the out-of-borough duties. And Baroness Hale, at this point, sets out the submissions of the intervener, the Secretary of State. And as was said by Lord Justice Lewison in a subsequent case, Baroness Hale effectively accepts these submissions. And they start by making it clear that local authorities have a number of duties to evidence and explain their decisions. One is the section 1.8 duty to take into account the guidance. And if they decide to depart from it, they must have clear reasons. Very good reasons are required to depart from a policy formulated after public consultation. You remember that's here, the policy about local authorities moving people far away from their boroughs where it's not necessary to do so. Referencing Calgan as being the case which said that there must be a proper evidential basis for the decision to offer accommodation out of borough or far away. Paragraph 32, it must be clear from the decision that proper consideration has been given to the relevant matters required by the Act and the Code. Whilst the court shouldn't adopt a nitpicking approach, the reasons given in the decision do have to be adequate to fulfil that basic function, not least because without it, it's not possible for applicants to tell whether or not there are grounds of challenge, and indeed not open to the courts to examine whether or not the authority have properly fulfilled their statutory obligations. So the positive obligation is subsequently described in the case law on the local authorities to evidence and explain how they complied with the in-borough and out-of-borough duties. And the Secretary of State's concern was that if the Court of Appeal's approach to these matters was permitted, then, as we'll see, the mischief that the order and the guidance was intended to address would in fact not be addressed. And the particular point that was taken was that it would be inadequate for the court to approve decisions which were effectively based on assumed knowledge of local authorities, it obviously being the case that everybody understands that there are shortages of available affordable accommodation in parts of the country. And then at paragraph 34 specifically, as regards the outer borough duty, the Court of Appeal had said, well, you don't need to deal with it in terms. You can be assumed as an experienced housing officer to understand what is required. And in paragraph 35, an important paragraph, the Secretary of State complains that the effect of this approach would be to encourage courts to infer on no other basis than the assumed experience and knowledge of a local authority that the authority knew of the code and guidance and had taken it into account. The authority had considered and rejected the possibility of providing closer accommodation than that offered, and that the authority had good reasons for their decision in this particular case. The courts are prepared to assume all of this in the authority's favour. This would immunise from judicial scrutiny the automatic decisions to house people far away from their home district, which was just what the 2012 order and supplementary guidance were designed to prevent. We then see the analysis of that case. In particular, the inquiries that were made in relation to the impact of the family in Enza moving to Bletchley were carried out after the offer was made as part of the review decision. The review decision is based on the premise that because the general shortage, I'm reading from paragraph 36, that because the general shortage of available housing in the borough, the authority could offer accommodation anywhere else unless the applicant could show that it was necessary for her and her family to remain in Westminster. And then material for our purposes doesn't apply exactly the same way, but in due course I'll be explaining why it applies in a material way. In our case, is the last sentence of paragraph 36. There was indeed no indication that the reviewing officer had recognised that if it was not reasonably practicable to offer accommodation in Westminster, there was an obligation to offer it as close as possible. And in paragraph 37, the conclusion, it wasn't possible for the local authority to discharge its positive obligation to demonstrate compliance with the in-borough and out-of-borough duties. And ultimately, this meant the appellant was unable to understand why it was she hadn't been offered accommodation that was closer than Bletchley, or indeed in borough, and therefore the appeal had to be allowed. Then there is some guidance by the Supreme Court about how local authorities may choose to go about demonstrating compliance with their obligations in individual cases. It's set out there at paragraph 38, all uncontentious facts that, of course, reasonable practicability imports consideration of resources, costs, etc. But identifying that the adverse consequences for other boroughs were a relevant consideration if you're routinely placing people outside of your own borough in terms of the knock-on costs and implications, both for the individual households concerned, but indeed, of course, for the other local authorities. And then in paragraph 39, ideally, each local authority should have and keep up to date a policy for procuring sufficient units of accommodation, etc. That policy must reflect the statutory obligations, should be approved and made public. And then a second policy for the allocation of accommodation to individual homeless households, how to deal with fairness in the context of retaining units at that point. And then at paragraph 40, sorry, just reading on, I should apologise, just finishing reading from paragraph 40. My apologies, just finishing paragraph 39, sorry. Where there's an anticipated shortfall of in-borough units, that policy would explain the factors which would be taken into account in offering households those units, the factors which would be taken into account in offering units close to home, and if there was a shortage of such units, the factors which would make it suitable to accommodate a household further away. That policy too should be made publicly available. This approach would have many advantages. It would enable homeless people and the local agencies who advise them to understand what to expect, what factors will be relevant to the decision. It would enable temporary letting teams to know how they should go about their business. It would enable reviewing officers to review their decisions made in individual cases by reference to those published policies and how they were applied in the particular case. It would enable reviewing officers to explain whether or not the individual decision met the authority's obligations. It would enable applicants to challenge not only the lawfulness of the individual decision, but also the lawfulness of the policies themselves. And then goes on to confirm that the policies themselves can be challenged on 204 appeals. And then in paragraph 42, no doubt there are other ways in which an authority could ensure that their decisions are properly evidenced and properly explained. If I could ask the court to turn over the next tab, tab 21. Don't worry, I'm not going to go through all the tabs. It just so happens the next case is the next tab. Now, this is a case called Albuquerque. Decision made by the Court of Appeal, judgment by Lord Justice Lewison. If I could ask the court, I'm just going to very, very quickly summarise these facts, then we'll come on to look at it, just so we're absolutely clear what we're dealing with here. It's actually two cases. It's Albuquerque versus Brent and Adams versus Westminster. Albuquerque versus Brent was a single man offered accommodation in Smethwick and Birmingham. He wasn't considered to be in priority need for in-borough accommodation, London accommodation, or south-east accommodation pursuant to the allocation policy. The main issue in the case was that although the reviewing officer's decision had said the accommodation in Smethwick was the only accommodation available for him, in fact, a witness statement was provided as part of the appeal, which demonstrated that in fact there had been at the time the offer was made another unit of in-borough accommodation and another unit of accommodation in West London. So squarely within the area within which the local authority had said clearly he did not enjoy sufficient priority to be offered anything in those areas. And the real issue in the case, if I can put it this way, was whether or not the decision was lawful, having regard to the obligations we've just seen set out in Enzo Lamiso, because it didn't clearly explain that those other accommodations had existed at the time the property that was offered was made, and did that invalidate the decision? And indeed, the circuit judge had found that it did. In particular, there was no evidence, there was no explanation as to why the accommodation in West London hadn't been offered. And at paragraph 66 of the judgment, we see Lord Justice Lewison's rejection of that argument on the basis that it was clear why Miss Albuquerque hadn't been offered that accommodation. He didn't fall within the relevant priority for it. It was a retained unit case, and therefore it was clear that that had been explained to him. And in fact, on a construction of the review decision, which was not nitpicking, whilst it was said that there was only one accommodation that had been identified, specifically, what the review decision did do, clearly, was say that such other accommodation that did exist within the borough, or within London, or indeed the southeast, was not going to be offered to him because he didn't have sufficient priority. And Lord Justice Lewison said, in that basis, it's clear why Mr. Albuquerque didn't get the property, and although the letter could have been expressed a bit better, that didn't ultimately matter. There are 2 points to this decision which are material to our case. One deals with the reasonable time point, and I'm actually going to leave that until I make my submissions on that. I think that's easier. I just want to deal with this point about the in-borough duty, sorry, the outer borough duty. And if I could ask you to turn to paragraphs 79 and 80. So, having identified the existence of the outer borough duty, Lord Justice Lewison then deals with how Brent dealt with that. Brent's review decision treats London and the South East together. It begins by explaining the shortage of social housing in Brent, goes on to explain that there is a chronic shortage of affordable private rented sector accommodation within both Brent and London and the South East, and that Brent cannot compete with other tenants for the limited supply of such accommodation. It explains that suitable affordable accommodation is only procurable in major conurbations. The review decision deals in terms with Brent's previous ability to offer placements in Luton, High Wycombe and Margate, and explains why that is no longer possible. Such units of accommodation that are available are allocated by applying Brent's policy. In my judgment, that is an adequate explanation of why Brent does not have access for accommodation within London and the South East. So there's the evidential basis for dealing with that part of the country. Once that area is eliminated, the West Midlands seems to me to be the next available pool of supply. And plainly, the decision could have stopped there. There is an adequate explanation, evidenced, as to why there is no accommodation in borough, or indeed in the major metropolitan areas, or conurbations I should say, between the borough and the area in which the accommodation is offered, the West Midlands. He does go on to say, it is, I suppose, theoretically possible that Brent might have been able to find somewhere in East Anglia or the East Midlands that was closer to Brent than Birmingham as the crow flies, but that places an onerous burden on housing authority. Mr. Westgate accepted that Brent was not required to scour every estate agent's window between Brent and Birmingham. In addition, the review decision explained that suitable affordable accommodation is only available in main metropolitan locations. So there we see that Lord Justice Lewison is able to grapple with an evidenced decision which explains why the closest accommodation to the relevant local authority, in that case Brent, was indeed in the area in which the property was offered, the West Midlands. Adams and Westminster is a different case with very different facts. And I need only mention that briefly. The facts are set out in paragraph 13. It's similar and therefore of no direct relevance to this case because it was another retained units case. Miss Adams had lived obviously in Westminster and she was provided ultimately with accommodation in Sutton.
Sutton, London, or Sutton, Coldfield?
I'm not sure, but the point is...
Sutton, London.
Sutton, London.
Sutton, London, yes. Yeah. The point is, it's the accommodation she was offered was within Band 2. So if we look at paragraph 15, Westminster had a policy, groups households into 3 bands. Those in Band 1 are given priority for offers of accommodation within Westminster and adjacent boroughs. Those in Band 2 are prioritised for offers of accommodation within Greater London. And those in Band 3 will normally be offered accommodation outside London. Policy states that the individual decision about placements in Bands 1 and 2 will take account of the availability of suitable property in the bands, and that any special circumstances demonstrating a compelling need for accommodation within either Band 1 or Band 2 will also be considered. It goes on to say banding is not a guarantee of anything. And penultimate sentence in paragraph 15, it's common ground that Miss Adam is not among those prioritised for accommodation within Band 1. Band 1, of course, is the band which includes the district, Westminster. And as we'll see at paragraph 69, Miss Adams' complaint did not involve any contention that she should have been offered accommodation even closer to Westminster than Sutton. It wasn't an outer borough duty case. It was only an in-borough duty case. And had the unpromising start that it was accepted that Miss Adams didn't fall within the priority bands for in-borough accommodation. And it is for that reason, one can infer, that counsel for Miss Adams raised a different argument, which was to say that the local authority should have waited to see if something in borough came up. And I said I was going to deal with that later. Let's perhaps just deal with it now. It's probably more convenient. It's in paragraph 73. So did I give you paragraph 69 for where it's confirmed that there was no, I'm grateful. So that being the case, we see paragraph 71, which is where Mr. Manning, on behalf of Miss Adams, raises his argument that Westminster made no real attempt to locate in-borough accommodation for Miss Adams, keeping in mind all the while that their own policy said that she was never likely to be given it because she didn't have sufficient priority based on her circumstances. And says in paragraph 71, the point being that they should have looked for accommodation for a longer period. At paragraph 73, Mr. Manning argued that housing authority must have some further obligation to assess whether it was reasonably practical to accommodate Miss Adams in borough, and that Westminster was required to assess whether it would be able to accommodate in borough within a reasonable time frame. Accepted that how long would be reasonable would be a matter for the local authority, and how much was necessary in order to fulfil the obligation of reasonable practicability. What an authority was required to do was to take an approach which gives them a reasonable chance of finding accommodation in borough. That's rejected at paragraph 75 on the facts. Not in principle, on the facts. The factual scenario that was material was it being an in-borough offer of accommodation that was an issue. The evidence being that in-borough was particularly severely constrained by supply. There was no point waiting any longer because there would be no prospect of a further affordable accommodation becoming available for Miss Adams in particular. It would have been a vain wait in hope.
You get that from paragraph 75?
I do.
I mean, the specific example that Lord Justice Lewison gives is the prospect of a development approaching completion.
Yeah, in borough.
In borough.
What he doesn't say, for example, is if you're in a scenario where you're not looking at an area where there are such high levels of demand, where there can be some realistic belief that accommodation that is closer might come up within that area in due course, then you may have to treat that as a relevant consideration. Which makes, if I may say so, rational sense. If you've got a reasonable practicability duty, you think, okay, well, there's nothing today, but there are some reason to believe it might come up tomorrow or next week. How can you demonstrate it's not reasonably practicable to wait a day or a week? You may be able to, but the point is waiting is a reasonable consideration in the context of the reasonable practicability duty, a material consideration in the context of the reasonable practicability duty. And Lord Justice Lewison is saying that in terms by reference to a factual scenario which wouldn't make it particularly worthwhile waiting because nothing's going to change, and then identifies as an example a scenario where that might be different, where, for example, you know accommodation is likely to come on stream in due course. And that's as far as I'm trying to take the point in terms of how Mr. Justice Lewison deals with that submission in that case. But the bottom line really is that Miss Adams' case is another one where there's clear evidence that the area in which she is suggesting she ought to have been placed is subject to very strict, very severe curtailment of supply. And in any event, there's a policy which says you're not somebody who's going to get it even if it does crop up. And in that sense, Mr. Alkabet and Miss Adams' cases are very similar. Just because I'm here at this stage, can I just finish with this case by just looking at what Lord Justice Lewison said about materiality of policies? It's at paragraph 48. He's really just nuancing what was said by Lady Hale and Zolamiso, saying that policies may be determinative in a particular case. Indeed, in the Adams and Westminster case, it essentially was, because it told Miss Adams why she was never going to get a property in Zone 1 in any event. And of course, just to make the forensic point, that of course, whilst in Westminster they had a similar type of banding, which was Zone 1, 2 and 3, district and neighbouring areas, Greater London and then the rest of the country, there was no similar argument to the one that's being raised before you about how you apply the outer borough duty in Zone C, because indeed Miss Adams was offered accommodation in B or 2. Just one paragraph in the next case, which is behind tab 24, which is the Salah case. It is a Waltham Forest case. I'm just taking you to it because it's a neat encapsulation of the freestanding nature of the out-of-borough duty at paragraph 26, which is page 443 of your authorities bundle. I could just invite the court to read paragraph 26 or mark it for your subsequent attention.
Yes.
The effect of that, of course, is the conclusion that a property which is far away, for example, is otherwise suitable or ostensibly suitable in terms of space, arrangement, and indeed location, may nevertheless be unsuitable if it cannot be shown that accommodation wasn't available that was closer to the borough in question. If I could then ask the court to turn to tab 31, the last authority I'm going to look at this stage in my submission. I'm going to deal with the ones on affordability when I deal with ground 2, because I can deal with them very swiftly. So Abtuladir is a case versus Ealing London Borough Council.
Sorry, could I have the reference?
It's tab 31, my lady, page 622 in the bundle. Now, facts are very different. Miss Abtuladir was offered accommodation very close to the borough, on the neighbouring, basically on the border of the borough, but in the neighbouring local authority. That's at paragraph 12. It was said by the local authority at paragraph 15 that it was the only property that was available for her. paragraph 16, we see something similar again with the zoning. Zones 1, 2 and 3. But of course this is a zone 2 offer, so again the issue arising in this case didn't crop up in Abdelkader. Paragraph 19, there was no challenge to the fact Miss Abdelkader was not entitled under the allocation scheme to a priority for in-borough accommodation. So it was common ground, again, that she didn't have any entitlement prima facie to accommodation in Zone 1. And indeed, just more generally, the question of out-of-borough accommodation, Section 208, was not raised on the review at all. And at paragraph 21, you see that the reviewing officer said in terms in the decision letter that that was the case. She raised 2 grounds of appeal, the first of which we're not concerned with, but the second ground of appeal we are, paragraph 47. The second ground of challenge is, in effect, that Ealing did not look hard enough. This too was not a point raised in the course of the review, for the reviewing officer did not discuss Ealing's temporary accommodation acquisitions policy. We, however, have been shown a copy of it, and it's explained what it says, what it purports to do, trying to identify demand for future accommodation, etc., references the legal obligations. Paragraph 48, one section of this policy set out its acquisition activities. They're all listed there. Goes on to explain that there is an evidential basis for saying it's going to continue to find properties hard to obtain in Ealing, and includes a statement at the end of paragraph 49. It goes on to say that it is certain that the council will not be able to meet temporary accommodation using need within the borough. I think it's clear what that's getting at. Then cross-refers to the 3 zones, etc. And then Lord Justice Lewison again deals with the obligation on the local authority to undertake inquiries in performance of its positive obligation. Just give me one moment, I'm just looking for a reference I can't immediately put my finger on. Yes, if I could just ask you just to see at paragraph 37 of that judgment. I'm sorry for jumping around a little bit, but I said I'd take you to where the subsequent cases refer to positive obligation. And it's paragraph 37, little 3. Of course, that's referencing the in-borough duty, but we say, based on Enzo Lamiso, which is a source of that statement of law, it applies and carries across equally well to the out-of-borough duty. So returning to where I was, sorry about that. So this is Lord Justice Lewison looking to see whether or not that positive obligation is fulfilled. He deals with case law, sets out obligations of inquiry. Paragraph 52, he mentions the cases, including Cramp versus Hastings, which suggests that the court might be hesitant to consider issues not raised on reviews unless they are obvious, particularly if they concern matters within the knowledge of the applicant. There's reference to the Paley case there, which is the one case I'm going to take to you on affordability. But then, contradistinction, paragraph 53, where it's a statutory duty, the decision maker must take steps such steps as are reasonable to inform himself of the practicability of an in-borough placement, even though the point has not been explicitly raised. And referencing the judgment of Lord Justice Bean in HHJ, it's not for the applicant to raise a red flag in circumstances where they have no input. That goes on to say this is not a case in which this is a new area of investigation, etc. It would have been well known to the reviewing officer she would need to show that they'd discharged their obligations under section 208. And then confirms that the one means by which you can evidence the compliance with the positive obligation is at paragraph 54, is the reference to the guidance. Sorry, it's the reference to the policy. And then paragraph 55 confirms that the availability of suitable accommodation is to be decided as at the date of the offer. The key point is that the policy is that acquisition officers liaise with accommodation providers and check relevant websites on a daily basis for new supply. And then paragraph 56, the real question as it emerged during the course of the hearing is whether Ealing actually complied with its policies. And at paragraph 57, Lord Justice Lewison says that they have not, they haven't provided any evidence that they did check relevant websites on a daily basis for new supply, and therefore couldn't demonstrate compliance with their own policy. Whilst that didn't necessarily mean the outcome would have been any different, paragraph 58, it wasn't such a case that it was inevitable the outcome would be the same, and therefore relief was appropriate. And then addressing directly the point that to analyse the local authority's decision in this way was risking judicialisation of welfare services, a point Lord Justice Lewison had himself warned against in Alapriguet. He says, well, yes, there's force in those points, but that's exactly what the guidance given by Baroness Hale and Enzoliniso was designed to protect against. Hence, we need to be vigilant in ensuring compliance, make sure those positive obligations are met. My Lord, my Ladies, if I can then move on to facts and documents in this case. If I could invite the court to turn up the skeleton argument, the original one, not the supplementary one. Background is given at paragraph 3 onwards. I'm obviously not going to read all of that out. I'm just going to supplement it with a couple of points if I can. My learned friend will tell me if I'm wrong, but I don't believe anything in this factual account, paragraph 3 to 18, is remotely contentious. You'll see, as I mentioned earlier, that the appellant approached the local authority in 2019 after the breakdown of her marriage. They were living together in private rented sector accommodation. She could no longer afford it. As a consequence, the landlord sought possession. Ultimately, a possession order was made in February 2020. In October 2020, whilst the appellant was still living in that property, 10 Lime Street, the local authority accepted the main housing duty, did not provide accommodation to her, as it ought to have done at that stage, until such time as she was actually evicted on the 29th of June 2021. The account of the facts, paragraph 8, would suggest there might have been a gap in time between 29th of June and 12th of July. There was not. The local authority did pick up the case at that point, I think provided bed and breakfast accommodation. In any event, she was accommodated from the 29th of June. And then the next document that isn't mentioned in there is an accommodation needs form that was completed on behalf of the appellant, which we see in the supplementary bundle, unhelpfully produced backwards. I believe it begins at page 42. completed on the 21st of July 2021. Identifies the household. Then affordability, financial information begins at the bottom of that page. Then we turn upwards to page 41. We see page 2 of that form, where it confirms income in terms of universal credit and child benefit. Then expenditure. A number of items are given there for bus, train fares, TV, internet, mobile phone, gas, electricity, water rates, etc. And again, scrolling upwards, we see the remainder of that: household shopping, toiletries, clothing. Forensic point, £40 a week for a household of 4 seems to be a low number for household shopping, but in any event, maybe that's just current day and age. No childcare arrangements in place. Scrolling up again. Some reference to medical and support issues. Caring responsibilities, where it said that the client doesn't have caring responsibilities and is not in receipt of carer's allowance. Some involvement with social services, but it was 4 years hitherto. Page 7 of the report, page 36 in the bundle, is applicant suitable for PRSO? Yes. Then it's signed by officer, Miss Addy Pegba, 21st of July. It says the form was completed over the phone on the 28th of June. Scrolling up again. Some issues about risk of violence in the risk assessment, none of which are answered. Then at page 9 of the form, after that risk assessment is completed, having considered all the information the accommodation needs form and on file, the applicant can be placed in Zone C. Again, that's signed 21st of July.
Sorry, where do you see that? Oh, I see the yes.
Yeah, it's a tick.
Yes, I see.
Is this the assessment that is being carried out, or is that a question that is actually asked of the applicant?
I don't know, I'm afraid.
That's an honest answer.
You think it would be the assessment?
I think it's the assessment, yes. And certainly that appears to be what was assessed effectively on the basis that the appellant was subject to the benefit cap. The final page of this form, which is actually, I believe, page 10, is helpfully at page 44 in your bundle. But it's not immaterial in the sense that this is where we see a specific issue about availability of supply and the extent to which the officer has considered this issue at the time this assessment is completed, which of course is the day before the accommodation is offered in Stoke.
So can I just understand, the top of page 44, it's sort of mid-sentence.
And it's also page 11.
Yes, it's page 11, you're absolutely right. Let me
I
just...
think you need to go to page 33 for page 10 and then page 44 for page 11.
I'm most grateful, thank you.
Ah,
Yes,
thank you.
thank you. So you see there the standard formula about accommodations availability in borough.
Sorry, which bit are you reading?
10, page 33, second paragraph, as there is an anticipated shortfall.
Oh, I see, yes.
And it references there the allocation policy.
Yes.
And then we come to page 44, which is the page page I was originally at. And there's a delete as appropriate. And as we can see, this part of the form hasn't been completed.
It should have been completed, shouldn't it?
Yes, it should have been.
Because at page 10, it says I've made a decision, the applicant can be placed in zone, and then there's just a blank.
Yes, I mean, I accept, however, that there is a reference to the officer concluding that she would be eligible for an offer in Zone C at page 9. But of course, that's only half the story. The real question is, must they be placed in Zone C? What's the state of supply? And of course, materially in this case, as we'll come on to see, did it have to be Stoke,
Well,
as opposed to somewhere near?
if you look at page 9, in respect of Zone A, there isn't even an entry. You've just got yes-no. And then in B, you've got yes-no again.
Yes.
And there are no reasons given.
No, not in this, no.
No.
No. We come on to find those reasons in the letters that are sent.
Well, this is not an unimportant document.
No, absolutely not, my lady. And this is where we see the officer who actually makes the decision to allocate this accommodation demonstrate her level of consideration of the statutory duties incumbent upon the local authority. And I didn't mean to suggest otherwise. I entirely agree that the fact that this officer didn't consider it is an unpromising start for the local authority's attempt to discharge the positive obligation.
So it comes to this, and I leave on one side unpromising or anything of that sort. But when she's considering the zones at page 9, she appears not to consider A or B, or if she did, there's no record of it. The only zone where there is any completion is Zone C. And then on page 10...
Just to be clear, do we know if Zone C is completed?
If you see that, it seems to me that it's darkened as if a highlighter had almost been put on yes.
Do you think?
And one hasn't got the yes/no.
No.
One's just got yes.
Yes.
But I can see there could be a, I don't know.
I'm told by my learner junior that the colour one clearly shows that yes is highlighted for
coloured.
Zone C, but there is
Yes,
no
it's-
other markings on A and B.
All right, so no entries are made in respect of Zone A or B. On page 10, I've made the decision the applicant be placed in zone. There is no entry there at all. And then at page 11,
There's nothing.
there's nothing.
Absolutely.
And of course at 9 or 34,
Yes.
under A and B, you've not just got the yes/no for you to delete as applicable, but you've also got in brackets, if no, please state reasons.
Now, this is relevant in this way because the reviewing officer's job, as we know from Abdul-Gadir, is to assess whether or not at the time the offer was made there was compliance, having regard to the facts as they then were. Doesn't mean it's impossible for a reviewing officer to cure defects, but only by reference to the facts that were present at the time. Certainly what this doesn't demonstrate is at this point in time there was any specific consideration of whether or not the applicant would be or could be placed in zones A or B, and, as we've seen from page 11, any consideration about what the current state of supply meant for where an offer should be made. What there is also in the bundle is a financial assessment that is undated, but it's at page 172 of the supplementary bundle, it's the last document in that bundle.
And who is this filled out by? And it's filled out as if Zaman was in Stoke-on-Trent. Well, her address is given as Stoke-on-Trent.
That's correct. That is correct. And in relation to one aspect of it, the rent, it's a rent which we understand to have been notionally the rent in relation to the Stoke-on-Trent property. And one assumes probably the same is the case for council tax. Don't know that for sure.
So, just taking up my lady's question, who filled this out?
We don't know, or at least I don't know. It doesn't seem to have an officer attached to it.
But these forms are filled out with information having been given by the individual.
Well, we saw on the 21st of July in the telephone call that happened a couple of days earlier, there were some figures given in that income form. And my understanding is they did come from the applicant. But they're not ones that have been created by the local authority.
And if we compared the entries in that form with the figures in this form, do we see the connection?
My recollection is they're all the same apart from rent. Perhaps I could just ask my learned junior just to double check.
Yeah.
We're just double checking council tax, but they're otherwise all the same apart from rent.
Yes, I see. So, presumably what has happened is that when they're checking whether the property in Stoke is a viable one, they've entered figures for that property, taking into account what they've been told and what they think is going to be the expenditure for the rent and possibly the council tax on that property.
Yes. And it is said elsewhere that that was the rent for that property, I believe, in the witness statement that's filed.
Yeah.
Just to be clear, the appellant's submission on affordability and its relationship to Stoke is the additional cost she would be required to incur to travel to and from London, as the review officer deemed she would have to do in order to maintain relationships with her family and friends in London.
I was going to ask you, is that therefore meant to be included in the £21?
Well, if it is, it's wholly unrealistic, but the £21 was the number that the appellant came up with, identifying her travel costs when she lived in Waltham Forest.
Because this is an issue that arose in Paley.
Yes, very similar. There are other aspects to the budget that the appellant described when she was living in Waltham Forest, which wouldn't necessarily carry over in the sense there may be other omissions. For example, the appellant is clear that she was helped with childcare by her family. But the main one, for your purposes, is the cost of travel, which is acknowledged to be something that was necessary but never factored in as a cost. And you'll notice under other, there's nothing in other either in this notional budget. So that was the extent of the inquiry. Then we see the offer letter at Core Bundle 191. You'll see that it's offered on 22nd of July 2021, acknowledges that the duty in relation to the appellant has existed since the 2nd of October 2020, decided to bring the duty to an end by the offer of private rented sector accommodation, introduces 65 Longshore Street. Practical arrangements for viewing are 2 days later at 4 p.m. Property cannot be held open for more than 24 hours. This will result in discharge. You will only receive this one offer. Then the statutory requirement to inform applicants of the consequences of refusing or accepting are set out under I must inform you in writing of the following, and her right to request a review of suitability. The statement at the end of paragraph C, the council considers this offer of accommodation to be suitable for you and your household. You'll remember that's a precondition to authorising the offer of accommodation. In reaching its decision that it's a suitable offer of accommodation to discharge our duty to you, the council has fully considered the 2012 suitability of accommodation order, which is the occupation order. Then it says the accommodation is based outside of the authority's district. Of course it is. It goes on to explain that there's a power to do that. Then says there are no significant disruptions to your household. You are not working. No significant impact on children's schooling. Identify schools that would be available. Satisfied it's suitable on medical grounds. Deals with amenities. All of which are set out in the order itself as being specific requirements. But I would point out that when she said the accommodation is based outside of the authority's district, she doesn't actually talk about the distance from the appellant's previous home, and it being 175 miles, or indeed what that would involve in terms of travel, etc. There's then material dealing with Article 3, which we don't need to concern ourselves with. And then at paragraph 4, which is at the bottom page 194, affordability. I'm satisfied that the accommodation is affordable, having fully considered the cost of the rent and any other expenditure relating to the property compared to the income available to you, and specifically outgoings which are needed for you to feed and clothe yourself and your household, to heat and light the property, and to cover all other reasonable living expenses. You are not working and in receipt of state benefits. You are offered the accommodation in Stoke-on-Trent because you are benefit capped, and the offered property is significantly more affordable than any 3-bedroom property within or near to Greater London, i.e. in zones A or B.
And is that the only reference? Well, it's not even a reference. Is that the only allusion to A or B?
Yes. Paragraph 8, dealing with the Children Act obligation, section 11. Carefully considered the overall needs of your children. There is no evidence of social services involvement, expressing concerns over your ability to provide care for them without external help. Satisfied that the particular needs and welfare of your children have not been compromised, or that there exist any serious concerns for the welfare of your children due to your household being placed in Stoke. I cannot find any reason to indicate that your children would not eventually adapt to their new environment. So that's the offer letter.
This, in theory, is a small point, but it isn't in terms of timing. Was this letter emailed?
I'm afraid I don't know the answer to that.
Can someone find that out? I say it only because there's a date on it, the 22nd of July.
Yes.
Miss Zaman is being asked to meet the agent at 4 o'clock on the 24th of July, and
Yes.
therefore the timing of receipt of the letter
It
is of
is
some
important.
significance.
Yes, I mean, we know that she didn't go, and she did ask whether she could have a virtual viewing. Yes.
Yes.
I don't know the timing, and I will find out. The other feature being that she was only entitled, as we understand it, to a one-way ticket to go and view it, which is a point that she specifically raised. But these are not features of the current appeal, but they are part of the background.
I mean, for what it's worth, I see an email address on page 191 to say this isn't part of what we're concerned with.
Is it usual for one to have 24 hours to accept an offer?
Well, I wouldn't wish to give evidence, but one certainly sees frequently in these cases very short timescales, yes.
Including to single mothers with 3 young children.
Well, I wouldn't wish to go that far, but what we have, there is a provision in the guidance which says thank you very much. Oh, in the county court. My learned junior, who's it's very usefully pointed out to me that in the skeleton below, which is at page 99 in the core bundle, but it may in fact just be in the code of guidance we have. Paragraph 1761 of the code says applicants should be given a reasonable amount of time to consider offers of accommodation outside their district. Considering what amount of time is considered to be reasonable, authorities should take into account how familiar the applicant might be with the district offered and the length of time that the household are likely to be living there. And it was indeed sent by email on the 22nd. And I think it's fair to say as well that subsequently, when representations were made, the local authority did extend the period of the offer for a couple of days to give the appellant a further opportunity to consider it. That was somewhat blighted by the fact that simultaneously bailiffs were turning up at the temporary accommodation and trying to evict her on the basis that the local authority no longer had any obligation to accommodate her because she didn't turn up for the viewing as scheduled. Indeed, before they discharged the duty, but on the back of the bailiff. No point to taking about this in a legal sense, but any longer. But they do feature as part of ground 3, and they were there. The sort of heavy-handed way in which this was handled obviously proved very stressful for the appellant. And as a consequence, she reacted. And doubtless it, to some extent, impacted her initial reaction to the offer, which she described as being inhumane. That may be a bit strong, but one can sort of understand it in context. I was actually going to take you to 2 documents. One is the first one from the solicitors, which is at 145.
In the supplemental core.
Supplementary, my lord, apologies. It's actually an email, I do apologise, and it's written the next day, 23rd of July.
And this is Camden Law Centre.
Yes, indeed. Who continue to act for Miss Zaman.
Yeah.
And at this point, they've obviously had limited opportunity for instructions, don't have a signed consent order even, but this is an email that's going off before the offer appointment, inviting the local authority to withdraw the offer on the basis that, or the 4 reasons that are set out there. And if, in the final paragraph, if the offer is not withdrawn, then whether or not Miss Zaman decides to accept it, she wishes to request a suitability review. In the event she decides to refuse the offer, she further requests interim accommodation pending the outcome of the review. And we know that ultimately that request was refused by the reviewing officer on the 30th of July.
It's been said time and again, hasn't it, that in normal circumstances, somebody offered accommodation would be very wise to accept it even if they don't like it, because they can challenge that by way of review.
Yeah. The difficulty here is when you're dealing with somebody in this scenario, if I can put it this way, you're in temporary accommodation, you're told do it now and given a one-way ticket. So she's got to uproot, go, and then work out her situation from there. That's, in essence, what she found difficult and stressful. And indeed, when she didn't attend, as I said, as we see that the bailiffs attended the property, we see that in an email sent on It's at page 155. In fact, it begins on the previous page, which is helpfully upside down, but the 27th of July at 12:44, we see an email from the solicitor.
Sorry, where are you?
Sorry, I do apologise. I'm at page 154
Of
of supplementary. I should point out that the vast majority of the time until I get to the review decision now, I'll be in the supplementary.
So you're supplemental 154.
154 is where the upside down page is, which gives you the date and time of the email.
Mine doesn't seem to be upside
No,
down.
not mine.
That's what's confusing me.
Oh, really? Oh, somebody's trying to sabotage
I can
my
see an email at the
myself.
bottom from Camden Community Law Centre, 27th of July, 12:44.
My learned friend is pointing out that there was further confusion. I don't want to elaborate this too much because it's not part of the ground. There was further confusion because she wasn't sure how to get the travel warrant and she wasn't sure if it covered her children or not.
Yes.
But in any event, she didn't go. And then you see this email where you see a bit more detail on page 155. Going through the sequence of events insofar as they seem to be from her point of view, including at the top of page 156, that yesterday on the 26th of July, agents attended Miss Zamon's accommodation. I think I may have called them bailiffs, so I apologise if that's incorrect, to evict her.
I mean, on the face of it, however one looks at it, this is an entirely understandable reaction, but it's not something we're concerned with in this court.
No. So the next point that is relevant is as I say, interim accommodation was refused pending the review on the 30th of July, and then on the next day, we see it page 160 in the supplementary bundle. Miss Zaman contacts Natasha Grant at the local authority. Of course, this information was in the file and would have been available to the reviewing officer in due course. Saying, as I mentioned earlier, that although she is a 3-bedroom family, she'd be willing to take a 2-bedroom private rented place so that the local housing allowance level locally is high enough. I will need a deposit and rent in advance. How do I go about making an application from the prevention fund? Goes on to talk about nervousness of some landlords about people on benefits, etc. And then, with my youngest going to school in September, I can go back to part-time work then. Will you be able to help me progress an application for housing benefit top-up payment until then? So she's here trying to manage her situation and is indicating flexibility in terms of size of accommodation, and indeed that she'll be going back to work soon, which of course potentially had the implications for whether or not she's benefit capped and for affordability just generally. Then we see submissions made on the review at page 163, sent by Camden Law Centre. Second paragraph, these submissions should be read in conjunction with all other submissions made on behalf of our client. Of course, we saw those early ones sent on the 23rd of July. We maintain the property in Stoke is not suitable, and the council was not justified in finding that it was suitable. And accordingly, the client still owed the duty. Distance of property from local area. So straight to the heart of the issue, the council will be aware when it's considering making an offer of accommodation out of borough, it's under an obligation to seek to secure accommodation as close as possible to the local area. Our client's housing file tellingly contains no evidence that the council sought accommodation any closer than Stoke-on-Trent. It's unclear whether efforts were made to secure accommodation in borough or alternatively in a neighbouring borough or indeed in the whole of Greater London. Difficult to imagine that had such efforts been made, the council would have been unable to find a single suitable property in the entire area. And importantly, final sentence, even if that were so, it simply defies logic that the council could not secure accommodation closer than approximately 3 hours away in Stoke-on-Trent. Then references an earlier document produced by the council which suggested that suitability should be governed by an hour's travelling distance, which of course was being exceeded in this context. And that forensic point is made on behalf of the appellant there. Follows that the council cannot have been satisfied that the property offered to our client was suitable. Then we go on to see some other points which are made about Article 3, which are not relevant, and then the conclusion. There is then a minded to letter sent by the local authority, which we see at supplementary bundle page 45. A lengthy description is given of the background to her housing application. And then at page 65 of the bundle, we see the extract from the Waltham Forest private rented sector offer policy set out. And at paragraph 76 of the decision, page 66, specific reference to the zones. And paragraph 3.3 of the policy, which of course I'm going to come back to in due course. And then review findings finally begin at paragraph 83. And the social aspects about suitability in relation to the property in Stoke are dealt with there. And then we come on to see the response to the submissions made by the solicitor about location at page 73, paragraph 115. Recognises that those submissions say, in the first sentence, the next ground is your housing file contains no evidence that your council sought accommodation any closer than Stoke. And then paragraph 116, in response to above, you failed to take into account that the council's resources are severely strained, etc. The local authority has to be conscious about the cost they incur for each property. Actual cost of procuring the accommodation charges for accommodation is higher than this, and this cost is incurred by the local authority. I'm just going to red flag that now, because it's clear later on in the evidence that this issue about cost is complete red herring in this case. There's no relevance of cost to why accommodation closer to Stoke was not provided within Zone C. Then there's description of paragraph 117, the fact that the appellant is on universal credit, that she failed to understand this, that if she was accommodated in Borough or even in London, she would run the risk of rent arrears at paragraph 117. And then we see descriptions about cost of 3-bedroom accommodation only in 1819. And then 120, it has been demonstrated that you would have been unable to afford accommodation in Zone A, considering the information on file. And then at paragraph 121, I checked our systems to see what properties were available at the time you offered the accommodation in Stoke. I wanted to check which properties were available, and if so, why these were not offered to you. I wanted to check what properties were available at the date and time of drafting the decision on the 28th of September 21, which I've also listed below. So the situation on the 22nd of July, when the property was offered, are then set out there, and a number of properties are identified. And you'll see quite quickly that all of those are zones A or B.
As of the 22nd of July.
As of 22nd of July. Of course, other than the property offered, which is the first bullet point. And then 28th of September, the date of this decision, minded to decision, a list of other properties, again in zones A and B. Specifically, 2-bedroom properties are identified as being too small. And then I hope that this has clarified the lack of available suitable properties for your household at the last sentence, paragraph 121. And I have demonstrated above why you were not provided with a Zone A property or a property in London. This is because there were no properties that were available and suitable for your household apart from the property that was offered to you in Stoke-on-Trent. And then in paragraph 24, in any event, when examining your case overall, it's reasonable for me to say that even if there were 3-bedroom properties available in London or near London, it is unlikely that they may have been offered to your family unit for the reason that you were a non-working household at that time, was benefit capped, and with children who were not at a critical stage in their studies. And if anything, it's possible that they would have been offered to families who would have fallen within the criteria for a placement within the borough or within London. So in answer to my lady's observation about assessment, about entitlement to being in zone A or B, this is where for the first time we see some reference to that in the decision making of the local authority. And it continues at paragraph 125, you had a relatively low level of need, etc. And then reference finally at page 127 to not having to scour every estate agent's window. So that's how that issue is dealt with in the minded to letter. We then have the submissions made on response to the minded to letter by the solicitor, which we see at page 166 in the supplementary bundle.
Can I just,
My lady.
it's page, no, it's just in passing because what were raised were a number of specific questions, weren't they? To which a number of specific questions were raised by
Yes.
the applicant.
Yes,
And they were responded to.
yes,
And it's just of note at page 85, where a request was made for a virtual tour of the maisonette.
yes,
And the response is you had an opportunity to view the property and therefore you would have got an idea of the property and its immediate surrounding. You failed to attend this, which is no fault of the council but your own.
yes.
Yes. Sorry,
I mean, we one of the points that's taken here is that the appellant simply had no intention of ever accepting this. And partly why ground 3 was there was because of, that was felt to be an unfair inference because it was inferred from circumstances in which she was put under considerable stress. And therefore it might have looked like she was stridently opposed, but that was partly because she wasn't given, she would suggest, the adequate time to deal with it.
But again, none of this matters for our purposes.
You can see how if we developed ground 3, we would have had to
Yes.
deal with silence. So I was just going to then deal with the response to the minded to letter sent by the solicitors at 166. And again, distance of property from the local area is picked up straight away. The same points are made. And then the paragraph beginning additionally on page 1467. Additionally, the minded to letter sets out the other properties that were available at the date of the initial offer. And at the date of the minded to letter, all of the properties listed are located within Greater London. However, the Council's accommodation acquisitions policy provides that where the Council is unable to secure sufficient numbers of properties in borough, it will address this shortfall by acquiring units in nearby locations, which are all there identified, which is they're all Zone B locations. And it says, it appears that the Council did not search for, or alternatively, in breach of its own policy, failed to acquire properties in those areas. Rather, having demonstrated that there was no suitable properties available in Zone A, fettered its discretion to offer a closer property and instead secured a property in Zone C, i.e. in Staffordshire. The Council has not provided any reasonable justification for failing at least to make an offer in Zone B. Further, and in the alternative, we submit the Council has unlawfully adopted a policy of rehousing homeless households in Stoke-on-Trent, presumably via supply agreement with a housing provider in that area. This is evident from the fact that over the past 2 financial years, the Council has rehoused 121 homeless households in Stoke-on-Trent, as per the enclosed FOI response. We submit that it's unlikely in the extreme that on at least 121 occasions, the Council was unable to secure a property closer to the borough than Stoke-on-Trent. Whilst we accept it not be possible for the Council to check every town and city in between, it was required at bare minimum to seek to secure and procure properties within its Zone B in accordance with its Council's own policies. It follows that the Council cannot have been satisfied that the property offered to the client was suitable.
So the sort of core idea is your procurement policy is wrong.
Yeah, if it's true that this was the only thing you had available, then something's gone wrong on the procurement side. in areas of the country where these stringent demands on supply are just not present, and you haven't said they're present.
I mean, subject to the 2-bedroom rather than 3-bedroom point, on the face of it, there was nothing else available.
Yes.
But then the complaint is, well, the procurement policy has gone wrong.
Yeah, subject to the reasonable time point and subject to the 2-bedroom point, that's correct. Although we still make the point about the deficiencies of the policy, but I'll come on to that in due course. But yes, that's right. We then come back to what happened on the procurement side, and this has been raised very clearly by the solicitors. And then the final point is at page 169, accommodation acquisitions policy. We submit that the council's failed to comply with its accommodation acquisitions policy, including as follows. The council has not provided any evidence that the relevant acquisitions process has been followed under section 6.0. Additionally, we submit the council has failed to secure adequate numbers of properties in borough and or near the borough, and or that the acquisitions policy is inadequate in providing that such properties will be secured. So that addresses my law's point even more directly there.
Yeah.
So we then come on to the review decision, which is in the core bundle, and obviously it's a subject of the challenge. Paragraph 126 is where we see the attempt, again, to deal with the points made in the submissions made on the 15th of September as supplemented on the 29th of September. And again, recognising the complaint here is, why isn't there anywhere closer than Stoke? Not an in-borough duty case.
I wasn't keeping up. Which page are you on?
I apologise. It's page 157.
Yes.
Paragraph 126.
Yes.
It's an extremely lengthy review decision, but it takes a long time to get to these points. But when we get there, this is what we see. So again, recognising that the gravamen of the complaint made on the review in relation to this issue is there's no evidence that you looked for anywhere closer than Stoke. And explains the reviewing officer understands that's supplemented by the 29th of October submissions. I'm not going to read them out again, we've just looked at them. And then the first line of response to that is, it's important for me to discuss your financial circumstances surrounding the unaffordability if you were residing in the borough or in a neighbouring borough first. So again, squarely looking at zones A and B. And goes on to explain that for a 3-bedroom property, at least, you wouldn't be able to afford anything in borough or in London. Goes on to talk about the fact that the claimant has now obtained work. And then at paragraph 137, it has been demonstrated that you would have been unable to afford 3-bedroom accommodation, one could write, in Zone A, considering the information on file and your individual circumstances. Then 138, your solicitor has attempted to challenge the council's policy by stating that it has failed to acquire properties in certain areas, so in breach of their own policy. In response to the above, you failed to take into account that the council's resources are severely strained. That's council's resources, not the supply of accommodation, but in any event. When sourcing accommodation, again, we see this point about the cost of accommodation, which I'm going to show you in due course is a red herring. Then at paragraphs 140, 141, I'm awfully confused with your solicitor's response to the Minded To letter because he's challenging the council's policies. However, in hindsight, this does not fall within the particular review. Labouring, one would imagine, under the assumption that you can't raise legality of policies on the review, which of course is not the case, as Enzo Lamiso confirmed. In any event, it's manifestly clear there is nothing unlawful about this arrangement in the way this council has procured their properties. Common knowledge there's shortage of supply, in-borough units, and as a consequence has to go outside of the borough because of the cost and pressure of the resources, which are relevant considerations. Correct for me to remind you upon 141 that this review is in regard to the suitability of accommodation offered in Stoke-on-Trent and not the method of procurement or the method of any procurement having any material impact on its suitability. As a result, this submission made by your solicitor needs no further scrutiny. It's now being dismissed as a matter of law. Talks about the submission made that there was a fettering, and at 143, I do not agree with the above, and makes reference to the availability of properties. And they're all listed again. They're the same as they were in the minded to letter. And then at 144, I have demonstrated above why you were not provided with a Zone A property or a property in London. And again, this is repeating what was said in the minded to letter. Focused on availability of 3-bed properties. And again at 146, even if there had been 3-bedroom properties, unlikely, but not, of course, definitive, that they wouldn't have been offered to your family unit. And if anything is possible, they would have been offered to other people, etc. And we finish with scouring every estate agent's window in the meantime. And then paragraph 148, so a final sentence. I do not accept that the council failed to make any efforts to provide you with a property in the borough, neighbouring borough, or even Greater London as stated by your solicitor. So just to summarise on the point on that, nothing in the review decision explains why the appellant was not offered anything in Zone C that was closer, save that perhaps it was the only property available on the particular day of the offer. There's no indication that this was about pressure on properties in Zone C generally or retaining units in Zone C for prioritised families. It's not about the cost of closer properties in Zone C. It's not about the affordability of closer properties in Zone C. It does not address why so little accommodation is available in Zone C.
Sorry, just keep up your list. Not about the cost of closer properties in Zone C. Do we know that?
Well, what I'm saying is what this letter doesn't tell you. It doesn't address. It doesn't say.
Whether or not it's a good point.
Yeah.
Might that not be alluded to in the references to cost?
So cost to the local authority, which is mentioned at 139, is the cost of temporary accommodation, which is clarified by the witness on behalf of the local authority. So
yes,
this is how much the local authority has to spend to secure property. That has nothing to do with securing property, which is PRSO,
yep.
And certainly doesn't demonstrate why closer accommodation within Zone C couldn't be made available.
Yep.
So what this decision letter really doesn't do is say, let me just give the list again. It doesn't provide any explanation as to why there was nothing offered closer in Zone C, other than to say there was only one property in Zone C on the 22nd of July 2021, which I'll deal with in a moment. But it doesn't say that this eventuality was the result of pressure on properties in Zone C. It doesn't say, you know, there's really bad problems in all those areas which have been identified in between Zone B and Zone C, between Zone B, and Stoke, which are the areas I listed earlier as by way of examples. It doesn't say it's anything about, as I said just a moment ago in answer to my Lord's question, about such properties being particularly expensive for the local authority, and neither does it say that they'd be unaffordable for the appellant. Affordability is about 3-bedroom properties in Zone A, potentially in London, which is part of Zone B, but not closer properties in Zone C, and certainly doesn't address why so little is available in Zone C, still less closer in Zone C. And of course, neither does it address compliance with Part 6 of the allocation scheme, which we'll look at in a moment. It just doesn't provide an explanation, other than by saying it was the only one available in Zone C on that particular day. On affordability, paragraph 160, which is page 184, the reviewing officer says you were provided with a suitable, affordable and decent home. There is nothing explicit in there about affordability beyond that. Paragraph 170 dealing with a different issue about how the family will adjust. But I acknowledge that moving to an area, this is page 185, sorry, bottom of 185. I acknowledge that moving to an area further away from family, friends and other associations would have initially made you feel isolated. However, relationships can always be maintained via modern means of communication. I'm also aware that not being able to visit your family, friends and your social network on a daily basis would have been an adjustment for you and your children. However, I consider that would have been a reasonably practical adjustment for you and your children whilst residing in affordable accommodation. And then goes on to talk about the father. Says, I noted from your file and as per your own admissions that your children's father sees them once or twice a month. I see no reason why he could not have travelled to see his children and or may plan visits, which would not have denied him the right to parental-child relationship, the right to respect for private and family life.
Is that the right way up? Is that normal in the sense of you know nothing about the father, but you just assume that it's so appropriate that he would travel to Stoke? Is it not usually put the other way up, given that he sees his children X number of times per month or whatever? An allowance has to be built in for them to travel to see him.
Well, I have to accept that the evidence from her is that they, whilst living in London, enjoy contact with their father by father visiting them in their home, because father only had a one-bedroom property. And the conclusion reached here is in relation to father. I don't see why that can't continue. There's no reference to any obstacles to that continuing or potential obstacles. I have to accept, however, that no such obstacles were raised explicitly by those assisting the claimant on the review. But I'll come on to what the obligations on the local authority were in terms of carrying out an affordability assessment, even in circumstances where specific points haven't been raised by the appellant, which is the Paley case. But on the first point about you'll come to terms with the fact that you're not going to be able to visit on a daily basis your family and friends, that in fact is a reference to paragraph 21 of the same decision, which we see at page 135, where recorded in the same decision is the observations made by the local authority to the claimant, appellant rather, about her contact arrangements if she were required to move. And it said, Miss Grant advised the claimant, the appellant, I do apologise, that it would be considered reasonable that that you would be able to travel back to this borough to visit family members.
Now, I can't find that on page 135. Could you tell me where I'm...
It's paragraph 21, the middle of that paragraph. Paragraph 135 core bundles. We're looking still...
It's confused by the reference to shopping tasks in between.
Yes, I'm sorry. Yes, it is. This is reinforced by the statement that's produced by the reviewing officer when she says, well, this is how contact would have been maintained by visits to London to see family and friends. And that's the cost that's never factored in to the financial assessment on behalf of the appellant. Let's turn to Miss Batt's evidence now, if we may, which is in supplementary bundle. So it begins materially at paragraph 11, which is page 109. It's headed in response to grounds 1, subsections 3 and 3b and 3c. You can see those if you want to look at them in the core bundle, or you can just take it from me for the time being that they are the ones which say you didn't perform your functions in relation to accommodation as close as possible to Waltham Forest. Where it said what's said there. I've already dealt with this in the review decision. Well, we've just looked at that. I've provided evidence as to what properties were available on the date of the offer. In answering why the appellant was not offered with Zone A property or Zone B property, this was because none was available, and in any event, the information financial analysis on file showed that the appellant would have been unable to afford the rent. Well, the review decision is slightly more slightly narrower than that, and says that it's Zone A and London, doesn't actually deal with the neighbouring boroughs as being unaffordable, and of course doesn't deal with two-bed. But in any event, paragraph 13, in terms of procurement, I took some further time to speak to Ms. Yasmin Hussain, manager of the procurement team, to ask whether or not accommodation is sourced in other areas. Whilst it says in Abicadet that you don't have to scour every estate agent's window, Ms. Hussain confirmed that when the team go out to procure properties, they seek to procure in all locations, including Essex, Hertfordshire, Kent, Surrey, Berkshire and Buckinghamshire, etc., and do not limit their procuring to certain locations only.
Those are all Zone B, aren't they?
They are all Zone B, yes. And then 14.
And so there's no reference to whether the procurement policy includes looking for places in Zone C that are closer than Stoke and Trent.
No. And more specifically, what was done in order to try and identify accommodation in those areas, which is exactly the point that's raised on the review by Camden Law Centre. Then it said at paragraph 14, we cannot run a service by keeping people in temporary accommodation for an indeterminate period in the hope that at some point in the unknown future, properties in a specific location become affordable for applicants, including those who are benefit capped. Well, that only has any force to it if one has some understanding of what you're actually trying to do to find accommodation in those areas. And, just to remind the court, these are very significant conurbations that exist between Stoke-on-Trent and Zone B, which were read out by me earlier, and I suddenly can't remember them off the top of my head. But the ones I mentioned were Norwich, Peterborough, Birmingham, Northampton, and Stafford, etc., which are all conurbations which are closer. Except you don't have to go to every town and village, but you've got to look at the main conurbations and see or demonstrate why you're not doing that in some way. In paragraph 19, just finish on this. Dealing specifically with procurement, which is dealt with by 16 onwards. More directly on my lady's point about where this search goes, paragraph 19. Moreover, the policy stipulates that in addressing the shortfall, the service will endeavour to acquire units in locations which are close to Waltham Forest in order to minimise, as far as possible, the distance between the borough itself and the location of accommodation being offered to households who cannot be accommodated within the borough. These nearby locations are, and it's all the Zone B areas. So no reference to going beyond that and looking at areas closer than Stoke. And again, the demand question is addressed only in relation to Waltham Forest and nearby locations. Doesn't say anything about demand in Zone C locations, which are closer. And again, that point is made absolutely clear in paragraph 23. So we accept that on the basis, if that evidence is had regard to, then there is at least an evidential base for saying properties are difficult to acquire in borough and in London, and potentially in whatever are described as nearby locations, which seems to be Zone B, but goes nowhere at all to the question in issue, which is why aren't properties available in Zone C, which are closer than Stoke. While we're on Ms. Batt's statement, if I could ask you to look at how she deals with affordability. It begins at paragraph 28. First, an important statement, first line. I carried out a proper assessment of the affordability of the property and considered the appellant's income and the reasonable living expenses of her household, as is apparent from the housing file and from the time she approached the respondent up until the offer of accommodation. It tacitly acknowledged there that the reviewing decision doesn't deal with this at all, and we've seen that it doesn't say anything about how this is done. Paragraph 29, to clarify, the income expenditure form is based on figures provided by the appellant when she was living in Waltham Forest. Acknowledged that public transport and no expenditure for childcare, presumably reflected the fact that the appellant's family, including the children's father, lived nearby. So there's an acknowledgement there that those figures reflected the scenario in Waltham Forest and not what it might be in Stoke. And then the last sentence, I believe, is potentially incomplete. Any proper consideration of the affordability of the property have reflected the fact that these costs and potentially the benefit cap in London is £442.31 per week and out of London £384. So I don't know what to take from that. My learned friend says that what that is a partial cut and paste from the appeal skeleton that had been filed on behalf of the appellant, which was in the possession of Waltham Forest by that time. Then there's a discussion about...
just a matter of language, what does it mean?
Well, I think it's clearly incomplete, isn't it? I mean, it seems to me that we don't know what it means. I don't know if the reviewing officer is going on to say, and we made some adjustment to take account of the fact that that childcare wouldn't be available. The father would not be living nearby. It's just completely opaque. Yeah. I'm not going to try and read into anything. The point is, if we can't decide now what it means, then that's really the end of it. At paragraph 31, we again see reference to the local housing allowance for 3-bedroom properties. And at paragraph 32, there's an analysis which, of course, isn't in the reviewing decision, but in any event, it's here. And I'm not taking any point about that at this stage. And I accept it wasn't raised in terms by those representing the appellant. But what it effectively says is, well, because you're benefit capped, the amount of money you have available for rent is very low. And true it is. But the important point here is, like many other families, she might have been required to contribute to her rent from her standard allowance. The point being made is that whilst in London, she has more standard allowance available to her to use as a contribution to her rent because she's not having to pay childcare costs, or indeed, of course, the cost of travelling elsewhere beyond the limited amount that's set out. And then at paragraph 33, it says...
Just at the end of 32, we get the assertion that the council offered the Stoke and Trent property because apart from there being no other properties available in Zone A and Zone B, there were no more affordable rents any closer to London.
Well, if that's a suggestion that more generally there's a problem securing affordable accommodation in between Stoke-on-Trent and Zone B, there's no basis for that in the allocation policies, acquisitions policies we'll come on to see in a moment. And it would be reading an awful lot into one line there if that's intended to be what it means. I mean, it seems to me it's more likely to be a reflection of the fact that there weren't any more affordable rents on the day in question.
Which is the point that the fact there was nothing else on the day. So,
yeah.
Yeah.
We'll see what my learned friend wishes to make of that point. But, if that was all expanded upon and explained, then we might be looking at a different scenario. And certainly there's nowhere, as it said, otherwise, that there's any problems acquiring accommodation in Zone C that's closer to Stoke. The paragraph I was going to take you to was... Give me a moment.
Oh, you're on 33. Yeah.
33. So here, the reviewing officer says, well, even if you did downsize to a 3-bedroom property, this point now having been raised on the appeal below, and move to example Essex, the benefit cap would still leave her with a shortfall of over £100 per week in her living money. Now that may be true, but again, I mean, what this really speaks to is the paucity of a proper financial assessment, because it's about what she might have been able to contribute to meet any shortfall in her rent. And at paragraph 40, just to confirm that the witness herself acknowledges in paragraph 40 implicitly that she's only ever really done any thorough assessment of 3-bedroom properties. She hasn't looked at the question of 2-bedroom properties. Paragraph 42 was the paragraph I was going to take you to make good my observation about cost to the local authority being a red herring. Paragraph 42 of her statement, Ms. Batt is confirming that the reference at paragraph 139 in the decision letter, which is the one my lord picked up upon, is only concerned with temporary accommodation. And it is true, if I can say this, that where local authorities are purchasing temporary accommodation at short notice for people in expensive areas, they often have to supplement over and above what's available in housing benefit. And then just on family visits, paragraph 47, Ms. Batt confirms that in relation to family members, she could have been expected to visit London to see them, or vice versa.
Yes.
But there's no serious discussion about what that would have cost. There's no discussion about what that would have cost. Finally, we do need to look at the policies themselves. The PRSO policy begins at page 5.
Yes. Mr. Burton, we're just coming up to 1:45.
I've done very well.
Your hopes earlier obviously haven't been fulfilled.
No, I'm very sorry about that.
I don't think you've wasted any time at all.
I'm grateful.
I think perhaps rather than launching onto the next document, we should rise now. We'll start again at 2:10. And for the moment, we'll see how we go.
Most grateful.
I will take your supplemental skeleton with me if I can just...
That would be an opportune time to read it, actually. That would be great.
Rise.